What is your dream job? Are you looking for a job or currently working? Well, if you do, you should keep labor law in mind.
What is labor? Generally, there's a lot of information or words that can be connected to the word labor. It can be work, job, employment, effort, or physical and mental suffering of an individual. But it can be considered as property, in which we can find on the 1987 Constitution, Article 3, Section 1, the Bill of Rights. It states that no person shall be deprived of life, liberty, or property without the due process of law, nor shall any person be denied the equal protection of laws. It means that labor is a property that no one should take away easily because there is a right process and the employees have their rights in their work. Whether you are a doctor, lawyer, vendor, teacher, or professor, or any works have the right for themselves. Walang mahirap, walang mayaman, lahat pantay-pantay at may karapatan.
Do you know what the Philippine Labor Law or Labor Code is? The Philippine Labor Code is the law that governs employment practices and labor relations in the country. This protects both employees and employers, ensuring that none is subjected to exploitation or unfair treatment. President Ferdinand Marcos issued Presidential Decree Number 442, which enacted the Labor Code on May 1, 1974. It is the decree that establishes a labor code amending and integrating labor and social laws to protect workers, promote employment and human resource development, and secure social justice-based industrial peace. It establishes guidelines for hiring and firing private employees and working conditions such as maximum hours and overtime, employee benefits such as holiday pay, 13th month pay, retirement pay, and guidelines for labor union organization and membership as collective bargaining. In addition, the Labor Code contains several provisions which are beneficial to labor. It makes it illegal to fire private employees unless legitimate or approved reasons, as defined in Articles 282 to 284 of the Code. The right to self-organization of a union is expressly recognized, as is the right of the association to assist on a closed shop.
Did you know how important labor code is? Well, let me discuss it to you. Labor laws are designed to empower as well as protect workers. They ensure that employer-employee relations are monitored, allowing both parties to be held accountable for their actions. There is a natural hierarchy between the employer and the employee. Understanding labor code allows us to know our rights as an employee, which enable us to speak up and to challenge the people who might treat us poorly in our workplace. When we are aware of our rights, we know that we should have a safe environment, free of discrimination, decent working hours, have adequate earnings, employment security, and equal treatment at work, regardless of our age, gender, race, religion, and ethnicity. The labor law also recognizes the right of employers to to regulate all aspects of employment, such as freedom to prescribe work assignments, working methods, regulation regarding transfer of employees, supervision of their work, layoff and discipline, and dismissal and recall of workers, but not the unlawful termination of employees. They also have multiple functions. The primary functions of labor laws are to provide equal opportunity and pay, employees' physical and mental well-being and safety, and workplace diversity.
Constitutional provisions pertaining to labor. Article 13, Section 3 of the Constitution. Article 13, Section 3 of the 1987 Constitution affirms that the state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunities for all. It shall guarantee the rights of all workers to self-organization, collective bargaining and negotiations, peaceful concerted activities including the right to strike, security of tenure, humane conditions of work, and the living wage, and participate in the policy and decision-making processes affecting their rights and benefits as may be provided by law. The state shall promote the principle of shared responsibility between workers and employers, and the preferential use of voluntary modes in settling disputes, including conciliation, and shall enforce their mutual compliance, therewith to foster industrial peace. The state shall regulate the relations between workers and employers, recognizing the rights of labor to its just share in the fruits of production, and the rights of enterprises to reasonable returns of investments, and to expansion of growth.
How can you say that a person that is working in a company is a learner or an employee? According to Article 73 of the Labor Code, a learner is defined as a person who is hired as trainees in semi-skilled and other industrial occupations which are not apprenticeable and which may be learned through practical training on the job in a relatively short period of time which shall not exceed 3 months. Learners may be employed when no experienced workers are available. The employment of learners is necessary to prevent curtailment of employment opportunities. So let us move on to employee. An employee is defined as a person who works under a payroll of a company, generally paid on a monthly basis of salary. Let us move on the types of employees. Our first type of employee, we have part-time employee. Part-time employees are individuals who work for less than 40 hours a week and are typically paid by hour rather than salary, and still considered as legitimate employees but may not be eligible for benefits. Full-time employee, also known as regular employees. These are the person who works on a minimum number of hours, defined as such by their employer, comes with benefits that are not typically offered to part-time, temporary, or flexible workers. Temporary employee. Temporary employee are those people that are hired on a temporary basis, often fixed a set in a short period of time, such as 6 months. Seasonal employee. Seasonal employees are hired based on the seasonal needs of a company. This type of employee is eligible for Social Security and unemployment benefits as they are not considered as a permanent employee. Leased employees. Leased employees is an individual that is hired by a staffing agency and then leased out an organization to complete a specific job. Contractual. It can be part of contingent workers like interns and consultants. This person is retained by an organization for a set period of time to perform a specific task or duty kailangan by the job. A handyman normally quote a fixed labor rate to complete the job specified by the client. Basically, a learner is a person who is acquiring skills that can be used in their future work, while employee are those who works on a company in exchange of wages, or what we call salary, and some other agreed compensations like benefits.
Hello sir, good morning.
Good morning, Miss Magno. This is your assigned duty, but you don't have to pressure yourself doing all of this today.
Okay sir, thank you.
According to Article 83, hours of work shall not exceed 8 hours a day, exclusive of the 1-hour lunch break. The Supreme Court explained the rationale of this provision to safeguard the welfare of employees and to minimize unemployment. It must be emphasized that work hours exceeding 8 hours can still be done provided that there is an arrangement between the employer and employee for work beyond 8 hours and that the corresponding overtime pay is given. An employee who performs work exceeding 8 hours is entitled to an additional compensation equivalent to his regular wage plus at least 25% thereof. Health personnel in cities and municipalities with a population of at least 1 million or in hospitals and clinics with a bed capacity of at least 100 shall hold regular office hours for 8 hours a day for 5 days a week, exclusive of time for meals, except where the exigencies of the service require that such personnel work for 6 days or 48 hours, in which case they shall be entitled to an additional compensation of at least 30% of their regular wage for work on the 6th day. For purposes of this article, health personnel shall include resident physicians, nurses, nutritionists, dietitians, pharmacists, social workers, laboratory technicians, paramedical technicians, psychologists, midwives, attendants, and all other hospital or clinic personnel.
Regine, lunchtime na, tara na. Let's go, let's eat. Gusto ko ng sisig.
Oh, is it lunch already? Okay, let's go so we can eat. Ang dami pa nating gagawin eh.
Excuse me, Miss Magno.
Yes, sir.
Can you revise this paperwork? I need it before 1. And after you finish it, bring it to my office.
But sir, I was about to take my lunch.
Excuse me, Miss Magno. Are you complaining? You will prioritize your lunch instead of your work?
Meal period are typically 30 minutes or more. These breaks are off the clock and employees do not have to be paid, as long as they are not required to perform any work of duties during this period. If an employee is still required to answer phones, write emails, or perform any other function of their job during this period, they must be paid for the entire meal break period. Additionally, meal breaks typically have no restriction on where an employee can go. If you require the employee to stay on site during their meal break, they may need to be paid for the break. Also, for the business owners who give breaks but do not follow these guidelines, may be liable for 2 times what would have paid the employee for their break periods. It is important to understand these rules regarding breaks in order to protect your business and your employee. According to Article 85, Meal period is not less than 30 minutes or an hour time off for regular meals of employees, which is non-compensable. Rest periods or coffee breaks running from 5 to 20 minutes shall be considered compensable working time.
How's your duty?
Hey! I'm so tired. Actually, I'm about to go home but I waited for you to handle you the things that you need to do. Also, don't leave the key of the gate somewhere, okay? And do your duty properly as always. Bye!
Sure, thanks.
Night shift differential. It is a night working hours that perform not less than 10% of their regular wage working hours between 10 p.m. to 6 a.m. This night shift hours is additional for employees that is willing to work at night, since it is majority for the employees because it's less than 10% of their salaries. How to compute their night shift salary? Every employee is entitled to night differential of night shift pay of net less than 10% of their regular wage for each working hours. In every shift, they have ordinary, rest day, and special holidays. Those are the shifts that employees compute their salaries on their shift even though they have a rest day or special holidays. In ordinary shift, the employee get 57 pesos per hour, but it also determined to 47 pesos per hour. In the rest day, it is different determined from the ordinary because the rest hours will go to 59 pesos per hour. In the double holiday and the rest day at the same time, it will more than money will go on because this part, it will go to 177 pesos per hour. This is how you compute the employee's night shift differential. However, the cost of living allowance, as known as COLA, it is not included in the night shift differential pay. It is based on the latest wage order. So the COLA integrated their basic pay to the employees. What are the benefits of night shift? Well, the benefits of this night shift can apply to all the companies except the first thing is those of retail and services establishments regularly employing not more than 5 workers. The second is kasambahay and persons in the personal service of another. The third one, managerial employees. The fourth, officers of members of a managerial staff. The last one is field personnel and those whose time and performance are unsupervised by the employer. It is more strenuous, onerous, than the work done during the day. Therefore, it is deserved greater or extra compensation.
Miss Magno, here are all your assigned tasks for today. I need you to finish this before tomorrow comes, even if you have to take overtime. Is that okay with you?
Alright, sir. I will try my best.
Reg, I'm going home already. Overtime again?
Yes, sis. Our boss gave me so many work for today. Take care.
Alright sis, take care.
Miss Magno, you're still not done?
Yes, sir. There are still many of these files left. I'm sorry if I'm taking too long to finish this.
What is overtime work? Overtime refers to any hours worked by an employee that exceed their normally scheduled working hours. While a generalized, overtime definition refers simply to those hours worked outside of the standard working schedule. Overtime commonly refers concurrently to the employee's remuneration of such work. The overtime rate of pay varies between companies and by specifics of the overtime, such as the number of overtime hours worked. Standard overtime rates include time and a half and the double time. Overtime pay refers to the additional pay for work performed in excess of 8 hours a day, plus 25% of the hourly rate for work performed in excess of 8 hours on an ordinary day, plus 30% of the hourly rate for work performed in excess of 8 hours a day on rest day, special holiday, or regular holiday.
Finally, it's weekend already. I can rest and watch Netflix.
Are employees entitled to Saturdays or Sundays off as their rest day? The answer is no. Weekends are not legally designated rest days, but it can be on any day of the week. There is a rest day of not less than 24 consecutive hours or 1 day for every 6 days of work. The employer shall determine the weekly rest day. However, they shall respect the preference of employee as their weekly rest day when such preference is based on religious grounds. The compensation for a holiday, or if for example Sunday was your rest day but you are working, you will receive the regular wage plus 30% thereof. As an exercise of your management prerogative, an employee can have more than one rest day. This is why most employees enjoy Saturdays and Sundays off. When employer may require work on rest day, the employer may require his employees to work on any day. A. In case of actual or impending emergencies caused by serious accident, fire, flood, typhoon, earthquake, epidemic, or other disaster or calamity to prevent loss of life and property, or imminent danger to public safety. B. In cases of urgent work to be performed on the machinery, equipment, or installation to avoid serious loss which the employer would otherwise suffer. C. In the event of abnormal pressure of work due to special circumstances where the employer cannot ordinarily be expected to resort to other measures. D. To prevent loss or damage to perishable goods. E. Where the nature of work requires continuous operations and the stoppage of work may result in irreparable injury or loss to the employer. And lastly, F. Under other circumstances analogous or similar to the foregoing as determined by the Secretary of Labor and Employment.
What is a regular pay? Regular pay means that the base amount paid a non-exempt employee on an hourly basis. Regular pay means regular, recurring pattern of pay for an employee while working his regular hours of work, including allowances, general holiday pay, premiums, but does not include overtime. The regular rate generally includes all compensation for employment, including an employee's hourly wage or salary and other types of compensation. The premium pay. Premium pay refers to the additional compensation for work performed within 8 hours on non-work days, such as rest day and special days. Straight time is calculated by multiplying the hourly base rate by the total number of hours worked. Shift premium pay is calculated by multiplying the shift premium rate by the number of hours worked on that shift.
Department of Labor and Employment, private sector employers must pay their employees or workers their holiday pay, specifically December holidays, except in retail and service enterprises that employ less than 10 people on a regular basis. Every worker shall be paid his or her usual daily wage during the holidays. To assist employers, Labor Secretary Sylvester Bello III released Labor Advisory No. 12 Series of 2019, which specifies how wages should be paid for the exceptional non-working days of December 8, 24, and 31, as well as the usual holidays of December 25 and 30. The following pay rules apply to special non-working days on December 8, Feast of the Immaculate Conception, December 24, additional special non-working day, and December 31, last day of the year. unless there is a company policy, practice, or collective bargaining agreement or CBA allowing payment on a specific day if the employee did not work. The no work, no pay concept applies. The 13-month pay is a mandatory compensation that is delivered to rank and file employees by the end of the calendar year. To offer a clear definition, President Ferdinand Marcos signed Presidential Decree Number 851, which became law on December 16, 1975. A bonus delivered as part of the 13 months' pay is not a demandable and enforceable duty unless it is either part of the wage or the subject of an express agreement. According to Republic Act 7641, an act amending Article 287 of Presidential Decree Number 442 as amended, otherwise known as the Labor Code of the Philippines, by providing for retirement pay to qualified private sector employees in the absence of any retirement plan in the establishment. Stated in the article, Section 1, Article 287 of Presidential Decree Number 442, as amended otherwise known as the Labor Code of the Philippines. Article 287, Retirement. Any employee may be retired upon reaching the retirement age established in the collective bargaining agreement or other applicable employment contract. In case of retirement, the employee shall be entitled to receive such retirement benefits as he may have earned under existing laws and any collective bargaining agreement and other agreements, provided, however, that an employee's retirement benefits under any collective bargaining and other agreements shall not be less than those provided herein. In the absence of a retirement plan or agreement providing for retirement benefits of employees in the establishment, an employee upon reaching the age of 60 years or more, but not beyond 65 years, which is hereby declared the compulsory retirement age, who has served at least 5 years in the said establishment may retire and shall be entitled to retirement pay equivalent to at least 1/2 month salary for every year of service, a fraction of at least 6 months being considered as 1 whole year. Unless the parties provide for broader inclusions, the term 1/2 month salary shall mean 15 days plus 1/12 of the 13th month pay and the cash equivalent of not more than 5 days of service incentive leaves. In retail, service, and agricultural establishments or operations employing not more than 10 employees or workers are exempted from the coverage of this provision.
Powers of the employee shall at all times be bound by this agreement and all applicable laws, having the power and authority examine all of the employee's work and make decisions about it. Standards of performance provided, however, the employee is exercise of such power and authority is always in the best interest of the employee. Authority must be exercised in the reasonable manner, in good faith, and accordance with previous practice. What are the 3 powers of employees? Power to select or hire an employer has the right to hire its own personnel in general labor. Regulations do not permit interfering with the employer's decision-making in the course of his or her business. Secondly, the determination of a worker's credential and fitness for employment is solely the responsibility of the employer management. The employer is free to make his own decision based on his own judgment and commercial acumen. In circumstances of illegal termination, all aspects of employment, from hiring through firing, discrimination, or those that the law may allow for. Second, power to control. The power of the employer to manage how the work is done is referred to the control, the absence, ability, regulate the employee with respect to the fourfold exam. Is an important compound of the fourfold test. There is no employer-employee connection when it comes to the tools and techniques of doing employment involving the parties. The power to dismiss or fire. Legal termination of firing for cause is typically most difficult to manage. By the definition, the employee in question is creating problems that negatively impact the business and may involve potential harm to coworkers. The causes that are grounds for dismissal run the gamut, including illegal activities such as stealing, revealing trade secret, dishonesty breaking, company rules, harassing or disrupting others' workers, insubordination, excessive, unexcused absence, and poor job performance by some objective measure.
What is a contract? It is a written or spoken agreement, especially concerning employment, sales, tenancy, that is intended to be enforceable by law. What is an employment contract? It is a legal document that contains all the terms and conditions of the job. Is issuing employment contracts necessary? Yes, the contract is important as it contains all the provisions you want to set with your future employees. Types of employment contracts. Permanent employee contract. It is a contract that will not expire until the employer or employee chooses to terminate it. It is applicable to the employees who work regular hours and paid on an hourly rate. Fixed term contract. It is paid between the employer and employee working for a specific term. And if the contract exceeds, the employee shall be regularized. Casual employment contract. It is neither regular, project-based, or seasonal. The employee engages in a contract where they have a flexible working schedule but no paid leave. Labor-only contract. This refers to the arrangement where the contractor or subcontractor merely recruits, supplies, or places the workers to perform a job or work for a principal. Why is it prohibited? It is an arrangement where a labor-only contractor is one which presents itself as an employer even if it does not have the capital to run a business or capacity to ensure that its workers are paid their wages and other benefits as prescribed by the law. It cannot independently undertake to perform a subcontract or service. Probationary employment. What does it mean to be a probationary employee? First is the probationary periods. The second one is it is used when hiring new employees or promoting employees into a new position. The last is it lasts from 3 to 6 months. Project employment. It defines as when the employee is hired for a specific project. It is an agreement made with the employer and the project-based employee that must contain the following: the full details of the project. Seasonal employment, whereas the employee is engaged to work under a given season. It is similar to project employment. If hired as a regular season employee, the employees have the right to demand work during the regular season.
Do you know the benefits of SSS, PhilHealth, PAG-IBIG, and separation pay? SSS, PhilHealth, and PAG-IBIG services and benefits constitute a small fraction of the government's social safety net. As a result, the primary goal of these organizations is to provide people with government-provided economic or social assistance so that they can achieve or maintain their higher level of living. And as a result of their separation from the employer's service due to death, sickness, and other physical disability, or for other reasons beyond the control of the said employee, such as decreased redundancy or the cessation of business operations, the separation pay is exempt for taxation.
When you have started remitting money for the government, You have reached the peak of adulthood. When you first start working, you will be required to sign up a slew of records that quite don't match your monthly salary. Why do you have to pay taxes, SSS in the first place? What happens if you are unable to go to work due to sickness, maternity, or old age? Is there a program that can help us to avoid loss of income? Who are the persons that are covered by this program? Every employee hired by private companies is obligated to register to Social Security System, or what we call SSS. It supports social fairness by protecting its members and beneficiaries against the risk of disability, illness, pregnancy, old age, death, and other unforeseen events that result to loss of income and financial hardships. According to my research, the members of the SSS are expected to contribute a set amount based on their pay. Here are the following that is required to register SSS. Employers, employee, a private employee, whether permanent, temporary, or provisional, a Filipino seafarer, a household helper earning at least 1,000 a month, an employee working in a foreign government, a self-employed regardless of trade, business, or occupation, voluntary coverage of separate members, overseas Filipino workers, and non-working spouses of an SSS member. Even with a single contribution, a person together with his beneficiary is still entitled to such benefit. Even people who haven't paid their payments in years is still eligible for the benefit of SSS. In most circumstances, it is more beneficial for a member of SSS to pay on a regular basis because it represents one's savings and investments for future eventualities and retirement. As a member and contributor, you should have all the rights to know and understand how SSS works and what's in it for us.
And next is the PhilHealth. Republic Act No. 7875, an act instituting a national health insurance program for all Filipinos and establishing the Philippine Health Insurance Corporation. This act shall be known as the National Health Insurance Act of 1995, as amended by Republic Act No. 9241 and 10606. Ngunit ano nga ba ang National Health Insurance Program? Ito ay isang social insurance program na kung saan sinasagot nito ang pagbili o paggamit ng health services na sakop ng beneficiaries. Layunin rin nito ang makapagbigay ng health insurance coverage kung saan sinisigurado na may akses ang lahat ng mamamayang Pilipino ng magandang kalidad ng healthcare services. And for PhilHealth, all employees are required to be contributors of this service. Republic Act 7875. Members are given health and hospitalization subsidies should they or dependent be hospitalized. Monthly contributions are based on actual employee monthly salaries, and the amount of employee contribution is matched equally by the employer. And under the Universal Healthcare Law, or also known as UHC, all Filipinos are automatically eligible to avail the government's health benefits packages. Though not all Filipinos are registered in the PhilHealth database, they may still benefit from PhilHealth coverage at the point of service. And next, we talk about the benefits of PhilHealth. First is the inpatient benefits, second is the outpatient benefits, third is the Z benefits, and last is the SDG benefits, or Sustainable Development Goals. And first, we talk about inpatient benefits. These benefits are paid to the accredited healthcare institutions, or the HCI, through all case rates. The case rates amount shall be deducted by the HCI from the member's total bill, which shall include professional fees of attending physicians prior to discharge. The case rate amount is inclusive of hospital charges and professional fees of attending physician. And what are the documents needed? first is the copy of member data record or PhilHealth benefit eligibility form and duly accomplished PhilHealth claim form 1. Where it is available, all accredited HCIs or the different case rate amounts for selected medical conditions are being implemented when done in primary care facilities, and only admissible cases shall be reimbursed. And next is the outpatient benefits. Day surgeries or ambulatory or outpatient surgeries are services that include elective surgical procedures ranging from minor to major operations, where patients are safely sent home within the same day for post-operative care. Payments for these procedures are made to the accredited facility through all case rates. The case rate amount shall be deducted by the HCI from the member's total bill, which shall include professional fees of attending physicians prior to discharge. The case rate amount is inclusive of hospital charges and professional fees of attending physicians. And here are the documents needed for the outpatient benefits: copy of member data record and duly accomplished PhilHealth claim form 1. These are available in accredited ambulatory surgical clinics or the ASCs. And next is for radiotherapy. The case rate for radiotherapy using cobalt is 2,000 pesos per session and 3,000 per session for linear accelerator. Includes radiation treatment, delivery using cobalt and linear accelerator. Claims for multiple sessions may be filed using one claim form for both inpatient and outpatient radiation therapy. May be availed of even a second case rate. 45 days benefit limit. One session is equivalent to 1 day deduction from the 45 allowable days per year. If procedure is done during the confinement, only the total number of confinement days shall be deducted. And next is for the hemodialysis. The case rate for hemodialysis is 2,600 per session. Covers both inpatients and outpatient procedures, including emergency dialysis procedures for acute renal failure. Claims for multiple sessions may be filed using one claim form for both inpatient and outpatient hemodialysis, and may be availed of even a second case rate or the full case rate amount. 90 days benefit limit. One session is equivalent to 1 day deduction from the 90 allowable days per year. If procedure is done during confinement, only the total number of confinement days shall be deducted. The procedure is exempted from single period of confinement rule, or the admissions and readmissions due to same illness or procedure within 90 calendar day period. And the third benefit is the Z benefits. The Z benefit packages include mandatory services for the totality of care that are essential for the treatment of the condition. Hospitality services such as accommodation, medicines, laboratories, and professional fees and other services or alternative guideline recommendations that may be needed by the patients.
PAG-IBIG, also known as the Home Development Mutual Fund or HDMF, PAG-IBIG is another form of National Savings Program and the financing office for affordable shelter. The total contribution is shared between you and the employer. The highest compensation per month subjected to PAG-IBIG's contribution is 5,000 pesos, and it means that the employer and employee will pay 100 each as the maximum contribution. The benefits of PAG-IBIG is housing loan, multi-purpose loan, calamity loan, and secured savings. An individual at least 18 years old but not more than 65 years old may register with the fund under voluntary membership. However, individuals shall be required to comply with the set of rules and regulations for PAG-IBIG members, including the amount of contribution and schedule of payment.
What is separation pay? Is the payment to a worker who is permanently laid off his or her job without his or her fault. An employee who voluntarily resigns from his or her work is not entitled to separation pay. is not required in case of an employee's resignation, but if it has become company practice to give separation pay for resigning employees, or if the employment contract provides for the payment of such separation pay, the same must be paid. The computation separation pay is based on the ground on which it is based. In case of termination due to the installation of labor-saving devices or redundancy, the employee is affected is entitled to a separation pay equivalent to at least his 1 month pay or to at least 1.5 month pay for every year of service, whichever is higher. According to Article number 282, the Labor Code, an employer can terminate an employee for just causes, which could be any of the following. Number 1. Serious misconduct or willful disobedience by the employee of the lawful orders of his employer or representative in connection with his work. Second, gross and habitual neglect by the employee of his duties. Third, fraud or willful breach by the employee of the trust reposed in him by his employer or duly authorized representatives. Fourth, commission of a crime or offensive by the employee against the person of his employer or any immediate member of his family or his duly authorized representatives. And the last one is the other similar causes. This type of termination is strengthened by the provisions of Article number 285 of the Labor Code, which recognizes two kinds of termination an employee can initiate: without just cause and with just cause. If the resignation is without just cause, the employee must give a 1 month advance written notice for resignation, commonly referred to as a resignation letter, to the employer to enable them to look for a replacement and prevent work disruption. If the employee fails to provide a resignation letter, he or she runs the risk of incurring liability for damages.
Labor laws mediate the relationship between workers, employing entities, trade unions, and the government. We hope that you gain some knowledge from what our group has presented.
Workers' rights
Should be
a central
focus of development.